Sorry, we're running just a little bit late. The last meeting ran over, so just in case you're wondering where we all are, we won't be too long, probably about another 5 minutes, so huge apologies for the wait.
Do I have
Everyone, again, apologies for the slightly delayed start. As I explained before the councillors arrived, we had a very, very long meeting prior to this, so we're underway. I just want to welcome our members of the public here, welcome our members of the Independent Māori Statutory Board, and welcome all the councillors. We actually have no apologies, and so we'll start off. I just want to make a few opening remarks because I think there has been an awful lot of discussion over the last few days about this issue. And for the members of the committee, just to remind us, in this really critical issue, we wear three hats. We wear one hat as regulator, one hat as owner of the port, and one hat as the strategic planning organisation. And today's hat, again, as we did in the last Auckland Development Committee, is simply the regulator hat, and it's a very small subset of that regulator hat, which is simply to decide whether or not to accept the notice of motion. And again, today we are simply discussing that notice of motion. I know there's been a huge deluge of emails with a wide variety of issues that have been canvassed, but that's not for today's meeting. We need to be looking at this issue as we enter into mediation from the perspective of our Auckland community, which means that we actually need to enter mediation in good faith, with good legal backing and good planning advice, and I counsel us to do that. On the wider issue of the port and the position of the port, this is absolutely of critical importance to our community, and we've seen that. You're here today because you care and you're passionate about this area, as are we. I don't think there's a single councillor around the table who isn't passionate about this area and about our beautiful harbour. But the bigger issue around the future of the wharves and the strategic plan for the wharves and the strategic long-term plan for the port has been canvassed, and the Mayor's made it absolutely clear that the Stage 2 study will be done once the unitary plan is completed, and that no one is stepping back from. That plan needs to be done, and no one's stepping back from that undertaking. And we've got the recommendations, they're part of our report. I just want to acknowledge our chairperson of the Watamata board, Shale Chambers, who has been in conversation with me over these issues for a long time, and particularly over the last few days. And it's really clear that we need to pick up the issue that we raised at the last Auckland Development Committee, which was how do we bring the stakeholders, many of whom are in the room today, around the table together with our other members of the community, our waterfront people and our ports, to actually put together the very sensible terms of reference and the scope for that long-term study. It's what they did in Wellington, and many of you will be aware of that. That all got off to a shaky start. There was an awful lot of pressure and stress and bad feeling involved, and then with the help of people like Ian Athfield, they worked out a good, transparent process, and they worked through all the issues, and we're determined to do the same. However, today is not the day for that discussion. Today is a fairly banal discussion. It is about
Banal?
Can I just clarify? I am Councillor Darby. You've been very active in this. I know that you're passionate. I'm just actually
Point of order,
chairing,
Madam Chair.
and I'd like to chair. Councillors, I have the right. I'm the chair.
Standing orders.
So they are fine. I've checked. So the issue today before us is to decide on the notice of motion. That's the issue that I'm going to chair very clearly. We will stick to the topic in hand, which is the notice of motion. And councillors, at the next Auckland Development Committee, we will have an opportunity to discuss in public the wider issues of how we progress this. So if anyone thinks that this is cutting off and stopping discussion on this issue, it isn't. So, councillors, I'm going to move
before
the
you do, Madam Chair,
recommendation
point of
that
order.
we go into
I'll
confidence.
second that, Madam Chair.
Point of
Thank
order.
you. It's been seconded.
I raised a point of order before you moved that
It should
motion.
not be heard in secret.
Councillor Watson.
Okay, I just seek clarification in terms of Standing Order 3.21 and 3.22. And that goes to the committee moving to hear public input and local input. And if we go to 3.21, it says that for every committee of council, aside from the hearings committee, that time be set aside for public input at the commencement of the meetings, and I believe this Auckland Development Committee meeting falls under the auspices of that, and also 3.22, which goes to the right of local board chairs to address meetings also. So, Madam Chair, I would move that this committee move to hear that public and local input, and I would seek a seconder.
Seconded.
I'll just explain, councillors, we did have some requests for public input, remembering that this is an Auckland Development Committee to simply deal with the notice of motion. We had public input at length, which we weren't obligated to have, but I specifically agreed to the public input at the previous Auckland Development Committee where this was covered. The requests that I've had for public input are from 3 organisations who are also submitters to the unitary plan. And councillors, I just remind you, this is a unitary plan process that we've embarked on. People have the opportunity to submit and be heard by the panel. This is us simply today discussing our support or not for the notice of motion. So,
Point of order, would you please address the query from the councillor? Do the standing orders apply? And if they don't, why don't
Darby,
they?
if I get a chance to chair, I will do so. I'm going to ask Rita to comment. We have the information at hand because we knew that question would be asked.
Councillor Darby and through the chair, Councillor John Watson. Standing Order 3.21.1 and 3.21 in general refers to public input. However, this meeting did not have a provision to public input. The reason for that was that this is common practice for us with extraordinary meetings, such as, for instance, the governing body meeting of 9th of December followed that practice. The meeting was called for to deal with the notice of motion, and that was the only items we had. There's no breach of standing orders on this point. Standing Order 3.7.13 states clearly that there is no default order of business for extraordinary ADC meetings. Well, it doesn't say ADC, but for meetings in general. And then Standing Order 3.7.14 says that items do not have to be included if they are not relevant to that meeting. Outside of these standing orders, which we don't feel that there's any breach for there not being any provision for public input at this meeting, there's Standing Order 3.3.2, which gives the chairperson the responsibility to decide on any matter that we feel that standing orders do not cover appropriately. So the chairperson is always consulted when there's any doubt. However, we followed common practice, which we do at extraordinary meetings, and we did not feel there was any doubt on this matter. And that is the reason why there is no public input at this meeting.
Point of order. At what point are you going to ask for declarations of interest? Because you've moved from 1 to 3 without dealing with 2.
No, we've only dealt with apologies. That's as far as we've got.
No,
the
you
others
moved-
have been
you moved to
raised as
exclude the
points of
public.
orders.
You
So,
jumped 3.
Councillor, we will, I'm sure, have the opportunity to raise those. Can we just, hang on, councillors? Let's just do these things one at a time. So we've got, someone has moved and seconded that we take public input at this stage. I, as chair, am not going to accept that. We've made the decision and we've made the ruling, and I've made it very clear that there will be public input at the Auckland Development Committee on this issue, public input as we bring our stakeholders group together, and opportunities for the public to comment on the wider issues that have been raised with us via email. Today is simply the acceptance or not acceptance of the notice of motion. There's nothing to add.
Just to check
Right.
under...
Councillors, I've
Point of order.
ruled on that.
You have made a ruling.
Clarification?
Absolutely, councillor.
Clarification. Would the chair accept a vote on the part of this meeting around the issue of public input and local board input? And if there is a majority in this meeting that would like to have public input and local board input, then surely why not? And that is the purpose of the motion that Councillor Watson and myself have on the table, that it be put to the meeting.
Point of order, Madam
Okay,
Chair.
I understand that, councillor, but we do need to deal with the issue in hand, which is the notice of motion, the receiving of legal advice around that notice of motion, and we're going to move on. I don't
Point of order.
accept the recommendation, and I have every right to.
Point of order, Madam
Phew,
Chair.
another point of order. Councillor,
You have made a ruling, as I understand it, under the Chairman's ruling final clause of 3.14.6, is that correct?
it is, we have it here.
Madam Chair, I therefore move that under Standing Order 2.1.2, suspension of standing orders, I move that
I second.
3.14.6, which states the chairman's ruling is final, be suspended.
Second.
Exactly. Thank you,
Moved and
councillor
seconded.
Lee. I don't accept it.
Well, you
So
have to
let's
accept
move
You
on.
have to.
Sorry, you're going to have to debate
Councillors,
it.
councillors,
You just can't,
You have no
no,
authority to accept.
councillors,
you have to comply with standing orders, madam.
we do. And the ruling that I have is that we can choose.
You cannot arbitrarily break the rules of this council.
Thank you, councillor Lee. So we move on.
Can we have, point of order, can we have a legal opinion
Councillors,
around this?
councillors, we're going to go round and round this.
No, we're not. We should have a
I'm
definitive
going
ruling.
to- And if we could just take a deep breath. I think everyone's pretty exercised about this. I know we've got a full public gallery, and I'm sure that people are fascinated with the quoting of standing orders. Let's, however, just be really clear about what we can and can't do, and I'm actually just going to seek some advice on that.
Yes.
Advice to you is based on the Standing Order 3.3.2, the chairperson to decide, and I'll just read the whole Standing Order out. The chairperson is to decide all questions where standing orders make no provision or insufficient provision, and all points of order, and any member who refuses to obey any order or ruling of the chairperson shall be held guilty of contempt. See Standing Order 3.1.1, 3.14.16. If any member disagrees with the chairperson's ruling, the member shall be entitled to set out his or her reasons for disagreeing and to have standing orders available to refer to, but the chairperson's final decision shall apply. So my advice to you is that the chair's ruling is final. In this case, the chair has ruled that for reasons set out, she is not accepting public input, and that's the end of the matter.
With all due respect, with all due respect, that refusal is enabled under a standing order. I'm asking that standing order be suspended as the standing orders provide.
Okay.
Point of order, Madam Chair.
Okay.
In other words,
can-
it's a democratic decision.
So councillors and the public, let's be really clear what we're doing here. Otherwise, we will spend the rest of the afternoon debating standing orders. The issue that we're addressing here is whether we agree with or don't agree with the notice of motion. The decision has already been made on the way forward for the unitary plan. We're either going to agree or disagree with that. This is not the opportunity now for a wide public debate on this issue, because at the moment, regardless of the information that people have been given, the real issue here sits on whether this is defensible by planners or not. We need to get the legal advice on this and the planning advice yet again around the notice of motion. With the greatest of respect to everyone who's here, these are the issues we need to grapple with. We know and have heard from and have met with and spoken to many people who are concerned about this issue. My suggestion, which is why I raised it at the beginning, is that we actually have the right process for that. I'm really keen to hear all these issues. Do they directly pertain to the non-complying versus fully notified discretionary? That's what we need to grapple with today, and that is why we need to be talking to our planners and our lawyers on that issue.
Point of order.
So I'm not, so I...
Point of clarification?
No,
Point of
Councillor,
clarification?
just let me finish. So I have ruled that we are not suspending standing orders
I have
because...
Point of
moved the
clarification.
procedural motion. It's been seconded by councillor Fletcher. I ask for my procedural motion to be voted on.
Point of clarification, Madam Chair? Point of clarification?
Clarification,
Can
Councillor.
I just also want to draw attention to 3.3.2, and it starts, the chairperson is to decide all questions where these standing orders make no provision or insufficient provision. That's the first test. Essentially, what is proposed does meet that test because the standing orders make provision for the suspension of standing orders. So you actually don't have to go any further. Now, if I'm wrong, I stand corrected, but I'd like to actually have some legal advice on this because I think the interpretation to this is fundamental to democracy around this council.
Here, here.
And trust in council.
So
So,
we'll...
please, can we have an opinion? I know Mr. Loughton is here, for example, from Simpson Grierson, and there probably are a few other lawyers in the room with some experience of local government law.
All right, councillors, we'll...
Is there a lawyer in the room?
There are many lawyers in the room, and I'm sure we will have someone give us advice on that. And remember, there are many lawyers in the room, which is the very reason why, if we are going to take legal advice on this critical issue around the notice of motion, which we might get to in the next few hours, we certainly want to do so with our lawyers and not have all of the submitters' lawyers present. Remember, there were 11 submissions on this issue in the unitary plan, not all of which are supportive of our position.
Mr. Loughton is
Some
our
of which
lawyer.
would like to see quite a different approach. So, no. We're really clear, the suspension of standing orders is not a procedural motion, therefore we'll move on. I ask
That
for...
is, I
and-
totally object.
Fair enough,
And I have
councillor Lee.
no recourse but to seek legal advice from outside this council if that is the case. That is an abuse of process against the public interest.
Thank you, councillor Lee. And in the public interest, we wish to make a decision today so we can enter
Point of
mediation.
clarification,
I am going to now move to conflict of interest. Councillor Fletcher, you wish to raise a conflict of interest?
I have no conflict, but I have a declaration of interest. I have chaired the Motutapu Restoration Trust for the last 12 years. I have been a founding member to that trust, which celebrates its 21st birthday this year. I am a member of the Hauraki Golf Marine Park Forum, and I have a passionate interest in the golf, and I believe that that should be on the record, and I would be interested in any other declarations of interest and associations with the Waitemata and the Hauraki Golf Marine Park from other councillors. I think it should be on the public record.
Their discretion.
Okay,
Declare our
I
love city,
think
that's a pretty good.
pretty much every councillor here
That
would need to
thing again.
declare a passion and interest in the Hauraki Golf, and if we don't have, we shouldn't be here. Any other
Yep.
conflicts of interest that people wish to raise? You have
Declaration.
conflict of
It's a
interest, Councillor
declaration
Walker?
as compared to a conflict, and that is membership of the Hauraki Golf Marine Park
Yep.
Forum.
We don't, that's not a conflict.
Congratulations.
Councillor.
Declaration.
It's a declaration.
Yep. Councillor,
It's a declaration of interest, and I'm also this council's, one of the council's appointments to the Hauraki Golf Forum.
so that's great. as...
Oh, well, I
okay.
think I'd better declare that I am the chair of the Working Party for the Marine Spatial Plan.
Okay, that's
The
good.
Hauraki Golf.
So we have people well informed. Member Ngamane?
Might as well declare I'm the deputy chair of the Hauraki Golf Forum.
I'm a citizen of Auckland.
I know, and can I just ask the public gallery, we all feel passionate about this, and nothing wrong with applause, but if we can just remember we are trying to conduct a meeting here, and sometimes it's very, it can get wet, and I don't think that's an issue we're going to address today. Let's hope to move this forward.
Point of clarification, thank you.
Councillor?
You took the liberty of a preamble, so my point of clarification is on some of the things that you said there. You said that the Mayor has made a commitment to the Stage 2 study. I have not heard the Mayor say that, though I am aware of a resolution that says endorse non-complying and then endorse a review of the Port Precinct provisions at the conclusion of the pending Stage 2 study. Why has the Mayor not proceeded with the Stage 2 study as the resolution of August 13?
I refer you to the meeting of April 13 where the recommendation was moved, the Mayor was there, and part of that where the agreement was for the Stage 2 study to start at the conclusion of the unitary plan. Nothing has overturned that.
It was overruled by 30 August, which said the Stage 2 study was pending.
Okay.
And it's pretty clear. So I'd like to know, why is the NZIER report titled Port Study 2?
Madam Chair, can I...
And who commissioned who commissioned that particular study? There is no resolution that commissioned such a shallow report. Who commissioned that report?
Madam
So
Chair,
I'll ask the Mayor to respond, and then we can probably get clarification.
Look, I'm not going to. You're absolutely right, Madam Chair. This is not the forum. The point of order is, have you opened the meeting for a broader discussion, or are we actually going to deal with the subject that we've been called together to deal with?
Thank you.
And the subject we've been called to deal
Did
with
the
is
Mayor
notice of
commission a
motion.
shallower study than
No.
intended by resolution?
Councillor, that's not on the order of business, and we can go into this when it's the
It
appropriate
informs the
time.
planning framework for the port.
I will ask that we have it's been moved and seconded that we go into confidence. I'm going to put that recommendation...
Sorry, that's not a motion. That's not a legal motion. Point of order, that is not a legal motion. You have to read out the full legal motion. The council cannot
then we
just
will.
move such a simple motion.
Take it
Okay.
as read.
Well, can we... The usual
And some of us
process
wish
is,
to speak to
councillor, that it is up there for everyone to read. It is a long recommendation, but if you're very happy for me to read it, then I will. So I've moved, and Councillor Cooper has seconded that the Auckland Development Committee exclude the public from the following parts of the proceedings of this meeting. Agree that Bill Loutett, Simpson Grierson and Ian Cowper, Meredith Connell be permitted to remain for the confidential item C1. Notice of motion, Councillor Chris Darby, proposed unitary plan, council position for mediation and hearings, City Centre Port Precinct. After the public have been excluded because of their knowledge of this matter, which will help the Auckland Development Committee in its decision making. The general subject of each matter to be considered while the public is excluded, the reason for passing this resolution in relation to each matter and the specific grounds under section 48, clause 1 of the Local Government Official Information Meetings Act 1987 for the passing of this resolution follows. The resolution is made in reliance of section 48, part 1, Part A of the Local Government Official Information Meetings Act 1987 and the particular interest or interests protected by section 6 or section 7 of that Act, which would be prejudiced by the holding of the whole or relevant parts of the proceedings of the public meeting, in public are as follows. This is why we don't usually read the whole thing out, because it is very long. C1, notice of motion, Councillor Chris Darby, proposed Auckland Unitary Plan, council position for mediation and hearings, City Centre Port Precinct. The reason for passing this resolution, the public conduct of part of this meeting would be likely to result in the disclosure of information for which good reason for withholding exists under section 7. particular interests where applicable. Section 7, Part 2G, the withholding of the information is necessary to maintain legal privilege, professional privilege. In particular, the report and attachments contain legal advice and the grounds for passing of the, there's more. In particular, the report attachments contain legal advice and legal services staff will be present to provide advice to support the discussion and the decisions on this item. Grounds under 48 Clause 1 for the passing of this resolution, the public conduct of the part of the meeting would be likely to result in the disclosure of information for which good reason for withholding exists under Section 7. And I'm just going to ask our Chief Executive, in case that's unclear to people, just to clarify, and if need be, Catherine Anderson, our legal counsel, will explain it. Catherine, straight to you.
The methodology that the Unitary Plan Committee and the Auckland Development Committee has adopted in relation to unitary plan matters is to consider the confidential matters in terms of council's position for mediation with public excluded. There are normal processes relating to mediation which makes that a standard process for the council in relation to a number of matters that are before a judicial forum like the Independent Hearings Panel. In addition, this paper here expressly responds to specific queries of substantive legal matters that have been asked and which are responded to, and it will be appropriate to discuss those with public excluded.
Thank you. And again, I guess for clarity, this is our chance to check our legal advice as we enter into mediation with partners who will also have legal advice. We need to make sure that ours is robust and that we can protect the rules that we're setting to protect the harbour as strongly as we can. Councillor Fletcher, did you have your hand up?
Thank you. Speaking to the issue, I would really like Catherine to respond, or whomever you would deem appropriate, perhaps Stephen. I can understand the point of confidentiality on specific legal matters, but there are some non-specific legal matters that I believe could be held in the open agenda. Catherine, could you speak to that, please?
Yes, in relation to the parts that might be interpreted as being expressly non-legal advice, they are in the context of council's position being determined for the purposes of a mediation, and that dispute resolution is classically and orthodoxly a part of legal privilege process.
Madam Chair, I wonder whether, because of your experience of chairing, whether this could be separated out and that we can have the opportunity for some general debate around the issues while councillors can respect that those matters that pertain to specific legal opinions be reserved for the confidential agenda.
Councillor Fletcher, we spent most of yesterday trying to tease this apart to see if we could achieve exactly that. When we tested the discussion, to be honest, everything turns back to the legal points that we need to be able to defend through what is an exceedingly clear legal process. The hearings panel is not a sort of a folksy council committee. This is an extremely robust legal process that we do not want to put at risk if we are to land the kind of rules that we would like to see landed to protect this area that is of such importance to all of us. We will not put that at risk.
But Madam Chair, as I understand it, we have not given yet sufficient weighting to the legislation surrounding the Hauraki Gulf Marine Park, which is specific in terms of the sense of belonging to New Zealanders and essential touchstone to nature. That advice did not come through the last development committee.
Yeah.
It did not come through from officers, and I think it negligent that officers have not given us what our statutory requirements are under that context.
3.9.2, Madam Chair. Needless, irrelevant matter, needless repetition.
We're dealing with the notice of motion.
Thank you, Councillor. I was going to point out that we are now creeping out of the scope of simply dealing with the notice of motion, and the debate on the floor at the moment is the confidentiality clause. So I'm going to Councillor Watson.
Okay, thank you, Madam Chair. And speaking directly to A there, the motion to exclude the public from the following part of the proceedings. We've heard a great deal about the legal risk to council here. I would suggest that there's even a greater risk, and that's a reputational risk to the Auckland Council in terms of responding to the desires or the views of its public, which haven't occurred as yet. I would suggest that within this format, and as has been suggested by Councillor Fletcher, there is the ability to take away the legal material that might be subject to mediation and to allow for a public input. We have people that have come across here from the North Shore and all over today to be part of this, such as their interest, and I would suggest to you that they're just a very small part of a greater section of the Auckland public. So I would say, as a councillor, and I think we are talking about councillors here, that the risk to our reputation in the public from excluding the public from participation in a section of this outweighs even the legal risks that have been put up by our council, and which can be dealt with in isolation. So I would say, Madam Chair, that the opportunity does exist for the public to remain, and to remain for part of the proceedings, and for the so-called division then to occur at the appropriate point. I would suggest that by shutting the public out here, that is extremely damaging to the reputation of the council, and what is perhaps the most important issue that's come before this council to date.
Okay. So, Councillor Watson, Councillor Casey, you next.
I'm just puzzled a wee bit, because when we made this decision in committee, there was no legal opinion present in the report, and nor were we given any verbal legal advice. So in effect, we shut the public out for nothing last time, and I think they've got the right to be here this time. I think the legal opinions can be dealt with, but I think just let them speak.
So, thank you. Councillor Lee?
Under the Local Government Official Information and Meetings Act, there is a provision for the council to deal with business confidentially, and this council and other councils do it all the time. The idea is to protect the public interests around sensitive negotiations. What I'm concerned about here, given the overwhelming bulk of the details on this issue, the notice of motion, the rollback of the non-complying status, the 20 hectares reclamation, have all been out in the media already. There is very little, if anything, that I can think of that is confidential, actually. And what I'm concerned about is this: the provisions of confidentiality which are there to ensure the public interests are being used to...
Councillor Lee, I respect your passion in this issue. I'd like you to respect the chamber. When you call a point of order, it's...
You don't respect standing orders, Madam Chair.
Oh, Councillor...
Don't need to lecture us.
Point of order, Madam Chair.
Let's not get personal.
Point of order.
No, hang on, we've councillors.
Madam Chair, just
Linda Cooper has a point of order.
3.9.3, limitation on speakers, that when three speakers are spoken for or against, you may rule to take the opposing view.
Yep, no, we're well on that. We've had Councillor Watson, Councillor Casey, Councillor Lee against. Is there a speaker for the recommendation? Councillor Al-Filipaina.
Thank you, Chair. It's interesting that Councillor Lee mentions the Local Government Act and protecting the public in regards to sensitive information, and that's exactly what we're doing here. Because I do not want any of the public who are submitters to the proposed Auckland Unitary Plan to be in the same room as we discuss our council's position. It puts in jeopardy, from my perspective, the Unitary Plan Committee that I chair and you are the deputy chair at. So for me, this has to be done in confidential, because we need to end up getting a position, at least to take through to mediation. The process, as everybody knows, is that then there will be hearings. Then there will be some recommendations from the Independence Hearing Panel to Auckland Council, to us. Then we will discuss it. So I am not prepared to end up going into open agenda, then close for confidentiality, then back into open agenda, then into confidentiality. I, as one of the councillors around this table, want to end up getting all the information without any disruption, so we can make an informed decision based on all the information as a position for us to take to mediation. Once the mediation is finished, they will end up, and I'm talking the wider public, that everybody is concerned, and I'm one of them. But at least when the hearings is finished, everybody will end up getting the position of Auckland Council and the position of the Independence Hearing Panel. So I am saying, through you, Chair, I am saying through you that this needs to go into confidentiality. Thank you.
Thank you. So, councillors,
Point of clarification.
Councillor, we've had
I'd
three
just like
speakers
some
against,
quick
and
clarification.
now speaker 4.
I'd just like some quick clarification. I mean, my understanding is that officers of this council are actively engaged in conversations with Ports of Auckland, probably about this issue. So I really do not see how, if that is occurring, why this matter should not be in public. Because the main parties that we're dealing with here are Ports of Auckland, in large part.
No, that's not clarification, that's making a
So-
point.
so-
I'm going to put...
So can I have some assurance about communications between officers of the council and Ports of Auckland around this issue?
Point of order, the words are wrong. It is not my notice of motion.
I'm going to put...
It is not my notice of motion.
Okay. So
It is the notice of motion of 9 members, and that's what the request to the Chief Executive clearly stated. I wasn't privy to the agenda run-through, as is normal, even though I am the Deputy Chair, and that's an error on your part.
Councillor, all of the signatures...
It's the notice of motion of 9 members.
And that's fine. We can change that.
Can you please put their names?
We will do that. No, it's fine. It's
Madam
fine.
Chair, Madam Clarification, please.
Clarification, yes. Member Taipare.
This motion is a motion to exclude the public from a public deliberations and discussions on a public submission on behalf of the public?
No.
You don't represent the public?
No, so we just, I think we...
No?
Can we just get really, really clear? We do represent the public. Absolutely.
Thank you. That's
The
all I
issue here, if we can... Sorry, I'm actually going to... We've been very tolerant around this, but we do, with the greatest of respect to the level of passion in this room, we have a legal process that we are obligated to uphold here. I know that everyone is concerned about the port and the issues of reclamation. We need to be able to go into this unitary plan mediation with a robust legal case so that we can actually deal with what are, at the moment, extremely relaxed laws and controls around reclamation. We seek to make them stronger. Not everybody agrees with us. Therefore, we would like to be able to take our legal and our planning case into mediation. That's all we're deciding today. We are not making decisions about reclamation, nor are we making any wider decisions around the port area.
Point of order. Madam Chair.
Point of order, Councillor Quacks.
I move that the motion now be put, and the motion is the confidentiality item.
Is there a second?
I'll second that. Division.
We will move, we've got divisions and recommendations coming out of our ears, but we need to do that one. There is no discussion. It's been moved that the motion be put. Can we do it by division, please?
Point of order, Councillor
you
Darby
can't. There
asked
is
that the
no-
names be put up there, and the
There
names
is-
have not been put up there.
And that will be changed.
And can we just
So
be
we
assured, as it came through in the debate, that there has
Councillors,
been
councillors,
no
councillors,
dialogue
I have
between
been
officers
reminded-
on this issue because of the
I
mediation?
have been reminded many times that you cannot speak after a motion be put, motion.
I just
is
want the
moot.
truth on that issue.
Good for you, councillor.
So, councillor, just to be very clear, you're voting on whether this motion is now put or not. Okay. His Worship the Mayor?
Aye.
Councillor Nye?
Aye.
Councillor Brewer?
Four.
Councillor Casey?
Oh,
Councillor Cashmore?
Four.
Councillor Clow?
No.
Councillor Cooper?
yes.
Councillor Darby?
Against?
Councillor Filipaina?
For.
Councillor Fletcher?
No.
Councillor Crum? Councillor Lee?
No.
Member Namane?
Against.
Councillor Penrose? Councillor Quacks?
Four.
Councillor Stewart?
Yes.
Member Taipari?
No.
Councillor Sir John Walker? Councillor Wayne Walker?
No.
Councillor Watson?
No.
Councillor Webster?
Yes.
Councillor Wood?
Yes.
Deputy Mayor?
Aye.
It's carried 14-9.
Thank you, councillors. The recommendation is carried. We will now put the motion.
By division.
And by division indeed.
So, councillors, just again to be very clear, you're voting on whether the public be excluded. So that is your vote, just to be very clear on that. His Worship the Mayor?
Aye.
Councillor Nye?
Aye.
Councillor Brewer?
Four.
Councillor Casey?
No.
Councillor Cashmore?
Yes.
Councillor Clow?
No.
Councillor Cooper?
Yes.
Councillor Darby?
Against?
Councillor Filipaina?
Aye.
Councillor Fletcher?
No.
Councillor Crum? Councillor Lee?
No.
Member Namane?
No.
Councillor Penrose? Councillor Quacks?
Four.
Councillor Stewart?
Yes.
Member Taipari?
No.
Councillor Sir John Walker? Councillor Wayne Walker?
No.
Councillor Watson?
No.
Councillor Webster?
Yes.
Councillor Wood?
Yes.
Deputy Mayor Hills?
Aye.
It's carried 14-9. We can pull the division.
Madam
Thank
Chair,
you.
point of clarification on the matter of whether officers have been in dialogue on these matters that we are
It's not a
No,
good
councillor.